In his 1824 autobiography, the Hungarian-born censor of Hebrew books in Galicia, Ignatius Fessler, writes that he had once been asked by the Habsburg Emperor Joseph II whether the Jews in Galicia had progressed in their culture. He replied that the simple Jew was unable to understand the Chaldean commentator named Rashi, whose commentary was printed at the bottom of their Torah. And as a result, the rabbis read into it various errors and superstitions. The censor then asked the emperor whether he would allow replacing Rashi's commentary with Mendelssohn's translation in all printed editions of the Pentateuch. "That won't do," replied the emperor. "Mendelssohn was a naturalist, and I don't want my Jews to become naturalists." Assuming that Fessler's account of a conversation that had taken place 37 years earlier was accurate, what did the emperor mean when he called Mendelssohn a naturalist? Perhaps the answer may be found in a review of Mendelssohn's Jerusalem written by Johann David Michaelis, the German Orientalist and biblical scholar. According to Michaelis, Christians considered Mendelssohn a naturalist because he was silent on the topic of the Messiah and had different opinions on the question of the eternal punishment. Yet, according to Michaelis, Mendelssohn was not only a sincere Jew, but also a sincere rabbinic Jew. He was silent about the Messiah because, according to contemporary Jewish religion, Jews can be saved without the intervention of the Messiah. Unlike Christians, Jews believe that the Messiah will come not in order to save their sinning souls, but rather to fulfill their hopes for a moral happiness. In the context of the Christian faith, concludes Michaelis, Mendelssohn appears to be a naturalist, but not in the context of the Jewish faith. Each person, Michaelis concluded, should be judged according to his own faith. It may be that the Catholic emperor understood Mendelssohn to be a naturalist in the sense delineated by Michaelis. But the stated reason why Joseph II did not want to expose his Jews to Mendelssohn's translation of the Bible was his concern for the Galician Jewish masses. As apparent in contemporary Austrian censorship laws under Joseph II, a clear distinction was made between books intended for the consumption of the general public and those for the educated classes. The latter were allowed access to almost any work, while the masses were kept ignorant of works that challenged conventional normative beliefs. They were supposed to be kept innocent, obedient, and God-fearing in order to ensure public order. Joseph's refusal to make Mendelssohn's Bible translation available en masse to the Jewish public in Galicia has been understood by some scholars as implying a blanket ban on Mendelssohn's works in the Habsburg Empire. In fact, there was no such a ban. A collection of Mendelssohn's philosophical works in Latin was printed in Vienna in 1783, and advertisement for it appeared in the Viennese press. True, his Psalms translation, like Lafayette's Physiognomy or Henning's philosophical works, was put under the censorship category of toleratur, meaning that it was restricted to be read by the educated. Phaeton, on the other hand, which was forbidden by the censor during Maria Theresa's reign, was taken off the censorship list of forbidden books by Joseph II. Certainly the Biur was never banned. Joseph's attitude to Mendelssohn was nuanced, complicated, and respectful. What was Mendelssohn's attitude toward Joseph II and his policy of reforms? Scholars have noted the direct and indirect references to the emperor in Jerusalem and in Mendelssohn's correspondence with his disciple and friend Naftali Herz-Homberg. Yet the importance of the Austrian context to some of Mendelssohn's arguments in Jerusalem has largely been ignored. In my talk, I will attempt to show its importance by first examining one of the longest footnotes in Jerusalem, 4 pages in the original published work. The footnote discusses a court case in Vienna where a Jewish woman filed for divorce after her husband had converted to Catholicism. I shall argue that Mendelssohn's point in the footnote should be understood in light of Joseph II's 1781 edict for non-Catholic Christians in Austria, i.e. Lutherans, Calvinists, and Greek Catholics, and its further application to cases of conversion. But first, some background. Before 1781, Protestants were not formally recognized by the Austrian state and suffered from many restrictions on their religious worship and on their civil rights. The 1781 Toleration Edict was viewed by liberals as a meaningful step in the right direction, and by the Catholic Church as a dangerous move that would hurt the Catholic religion. Article 6 of that edict stipulated that contrary to the requirement that had hitherto been in effect, according to which all children in a Christian marriage where one spouse was not Catholic had to be raised as Catholic, from then on, only if the father was Catholic would all the children have to be educated as Catholic. This was to be considered a prerogative of the dominant religion. If the father was Protestant and the mother Catholic, then the education of the children should be according to their gender. Daughters would be educated like their Catholic mother, and sons like their Protestant father. And now to the footnote in Jerusalem, a work written as a response to a small book, The Search for Light and Right, published in 1782 by an anonymous author who signed his name as S and his place of residence as Vienna. Mendelssohn suspected that the author was Joseph von Sonnenfels, an Austrian jurist and member of the state administration. After the publication of Jerusalem, it was discovered that the author was August Kranz from Berlin. The Search for Light and Right challenged Mendelssohn's portrayal of Judaism, arguing that Judaism, contrary to Christianity, is a religion based on coercion and threats of severe punishments. In his Jerusalem, Mendelssohn attempted to show that the reverse was true. The footnote appears at the end of a section explaining the idea of natural rights and contracts, using marriages and the rights and obligations of parents and children as an example, and before the section where Mendelssohn considers the question of the legitimacy of the use of power and coercion by the state and by the church. Mendelssohn starts by asserting that when two people of different religion marry each other, the mutually agreed upon marriage contract handles the way in which they would like to conduct their household. But what happens when one spouse converts to a different religion after the marriage? It is at this point that Mendelssohn paraphrases a footnote from The Search of Light and Right. Quote, "A Jew in Vienna who converted to the Christian religion is said to have expressed his desire to retain his wife who has remained Jewish, and legal proceedings are said to have been initiated. The aforementioned author decides according to the system of freedom. One rightly supposes that a difference of religion cannot be recognized as a valid cause for divorce. According to the principle of the wise Joseph, difference of opinion in churchly matters cannot stand in the way of social ties." End quote. According to The Search for Light and Right, the converted Jew was called Arnstein, and the historian Jacob Katz tentatively identified him as Joseph Arnstein, the youngest son of the wealthy Viennese Adam Arnstein. There are problems with that identification, but I won't go into them here. In his response, Mendelssohn criticizes his critics' view on the pending court case. Quote, "I hope an emperor as just and as wise as Joseph will not permit the system of freedom to be misused to inflict oppression and violence. If marriage is merely a civil contract, and it cannot be anything else between a Jew and a Jewess, even according to Catholic principles, the wording in the conditions of the contract must be interpreted and explained in accordance with the intention of the contracting parties, and not those of the legislator or judge, unquote. Mendelssohn does not explain the phrase system of freedom, but from the context it seems that this is a reference to the 1781 Toleration Edict, specifically Article 6. This is even more apparent in the last paragraph of Mendelssohn's footnotes, where he talks of Mendelssohn's footnote when he talks about the education of children in the case of conversion, a topic not mentioned in the search. Mendelssohn asserts that as long as there are no impartial educational institutions in the state, quote, it is evident that the prerogative to educate the children belongs to the parties that has remained true to the principles formerly common to both. An emperor as just and as wise as Joseph will surely not permit such violent abuse of the power of the church in his state, unquote. Mendelssohn positions the prerogative of the parent who had not converted against the prerogative of the dominant religion in the Austrian state, mentioned in Article 6 of the edict. He rejects any interference of a legislator or judge in matters involving contracts, like Jewish marriages, and declares, even if the entire state were to have different views on this matter, it would have no influence on the meaning of the contract. Interestingly, in the last paragraph of Jerusalem, while criticizing the idea of the union of faith, Mendelssohn writes in a footnote, alas, we already hear the Congress in America striking up the old tune and speaking of a ruling religion. Clearly the concept of a dominant religion and its recent use in the legal sphere was on Mendelssohn's mind when he wrote Jerusalem. Although Article 6 speaks of a marriage between a Protestant and a Catholic and stipulates how children in such a mixed denominational marriage should be raised, Mendelssohn claims that the case of conversion of a spouse after a couple entered into marriage is a different story, since it forces a spouse who did not convert to maintain a household different than the one implied in the marriage contract. This constitutes a breach of contract, and the woman should be allowed to file for divorce, citing the conversion as a reason, to ensure a freedom of conscience. Instead of the characterization of Joseph as wise, Mendelssohn expresses his hope to his critic, whom it will be recalled he mistakenly thought to be the Austrian jurist Sonnenfels, that Joseph will be as just as he is wise in evaluating such a case. Several months after the publication of Jerusalem, Mendelssohn wrote sardonically to Herz Homberg in Vienna, quote, many thanks for all toleration if an avowed purpose is still the union of faith. Because the emperor is tolerant, a wife is to be forced to live contrary to the agreement entered into in matrimony with a husband who wishes to bring up the children according to his changed religious principles. All of these are abuses and distortions of the emperor's viewpoint, unquote. Article 6 had abolished the canonical promises according to which the non-Catholic party agreed to raise all children in the Catholic religion, and had introduced a compromise by which only if the father is Catholic, all children had to be raised as Catholic. Christians of different denominations who entered the marriage were aware of this condition, and in that sense, it was part of their contract. It was a juridical misuse of the emperor's principle of toleration in cases of conversion that suppressed the freedom of conscience. What made this a particularly pressing issue was the promulgation of the Austrian marriage law on January 16, 1783, when Mendelssohn was still working on his Jerusalem. If until then, marriages were the business of the religious communities, it now became the business of the state. The first paragraph of the new law declared, the marriage in itself is considered a civil contract. Although the law required that all appropriate religious marriage ceremonies and made them the law of the land, it relegated marriage disputes to judges in civil courts. In the case of non-Catholic Christians, this also meant the handling of divorces. This is when the question of conversion entered the discussion. And indeed, in the case of non-Catholic Christians, Article 6 of the Edict of Toleration was used also for conversion cases, citing again the prerogative of the dominant religion as a reason. In addition, it was stipulated that if one spouse converted to Catholicism, a mutual consent was needed for divorce. Conversion, according to the new law, could not be used as a reason for divorce in a mixed denominational Christian marriage. The decision regarding non-Catholic Christians were formulated several months after the promulgation of the marriage law, and Mendelssohn might have not been aware of them. In the meantime, it was the civil courts that determined what should be done in a case of conversion using Article 6 as precedent. In any event, none of those decisions applied to Jews whose treatment was postponed to a later stage. Whether Joseph was aware of Mendelssohn's criticism in Jerusalem against the Austrian system or not, he clearly thought of a unique legal path for Jews. On November 1784, the emperor approached the Jews of Galicia, the largest and most traditional element of the Jewish society in the monarchy, and suggested to them to make Mendelssohn's work, The Ceremonial Laws of the Jews, an ordinary Austrian law codex in litigation between Jews. The Ceremonial Laws was a summary in the German language of Jewish legal rulings concerning contracts in the area of marriages, wills, inheritance, and guardianship. It was composed by Mendelssohn after the Rabbi of Berlin sought his help in response to the request of the Prussian government to prepare such a text. The German law, it should be noted, stipulated in 1750 that Berlin Jews should use only civil courts, but the courts continued to rely on Jewish law in the areas mentioned above because they entailed contracts. This made the courts dependable on the mediating role of rabbis. In an effort to eliminate this dependence, the government wanted to provide the judges with a manual in German that would outline and explain the relevant Jewish laws. When the finished work was delivered to the Prussian government, it was accompanied by a letter written by the elders of the Berlin Jewish community. Mendelssohn was not one of them, emphasizing that the summary is an informative tool, but in no way an authoritative text according to which one could draw legal decisions. Making legal rulings, they added, requires knowledge of Hebrew as well as a command of all halachic sources. When the German summary was published as a book, under the title Der Ritualgesetze der Juden, that letter appeared as an introduction, and some assumed that the introduction reflected Mendelssohn's own position. However, Mendelssohn's position on the question of a Christian judge ruling on cases between Jewish litigants was a positive one. The Prussian authorities did not grant the ceremonial laws a formal recognition, although we know that it was sometimes used in Prussian courts. It was Joseph II who sought to grant the work a formal recognition and make it an integral part of Austrian law. But, as it turned out, the Jewish Galician representatives, rabbis, and communal leaders were not impressed by the gesture and rejected the offer. They justified it by the claim that even Mendelssohn himself declared in the introduction to his work that Jewish law contains many small and intricate details which make it difficult to master without knowledge of the Hebrew language. In addition, the Galician representatives argued that the work was too short and concise to fulfill the role that Joseph was ready to grant it. Making it a useful source would demand many additions, something that would take many years to complete. But Galician Jews went further and demanded to keep for themselves legal autonomy, at least in matrimony, inheritance, and guardianship matters, claiming that such legal autonomy is an essential part of Judaism. Any harm to it, they emphasized, would constitute a blow against the Jewish religion. And so the special legal treatment of Jews in the area of marriage contracts with the help of a Mendelssohnian work never materialized. A few months later, on April 1785, Joseph II abolished the rabbinical courts, allowing them to function only as courts of arbitration. Was Mendelssohn aware of Joseph's initiative to use his work? I have not found anything that might shed light on the question. I assume that Joseph learned about the ceremonial laws from Christian Wilhelm Dohn's 1781 book on the civil improvement of the Jews, where it is mentioned in a footnote as a helpful tool for judges. We know that Joseph Sonnenfels passed a letter to Mendelssohn via Herz Homberg 1 month after Joseph II offered Galician Jews to use the ceremonial laws, inviting him to be a member of the proposed Austrian Academy of Sciences. Mendelssohn gave a positive reply, but complained to Homberg 9 months later, and just 3 months before his death, that he heard nothing further from Sonnenfels. We can only guess whether inviting Mendelssohn to be a member of the proposed Austrian Academy of Sciences had anything to do with the possibility that his work was almost included in the Austrian law books. Would the inclusion of the ceremonial laws in the Austrian law have made a difference in the case of conversion? I think it would have, because of its legal status as a codex applying specifically to Jews, thus eliminating the need to use a Christian model as a basis. In any event, after the abolishment of the rabbinical courts in Galicia, the State Council started the application process of the marriage law for Jews, a process that lasted about 4 decades. Examining the deliberation of the State Council, which took place about 2 years after the publication of Jerusalem, one can detect a clear echo of Mendelssohn's criticism on the Viennese divorce case, although his name was not mentioned specifically. The majority supported the suggestion of one of the members that in the case of conversion of one spouse, A, the spouse who remained Jewish would be allowed to file for divorce, meaning to cancel the requirement for a mutual agreement in such a case, and B, if the children were born prior to the conversion, they should be raised in the religion of the spouse who remained Jewish. This sounds like a full acceptance of Mendelssohn's 2 criticisms outlined in his footnote, and it seems unlikely that it was just a coincidence. After all, the State Council members had not just suggested the same for non-Catholic Christians. Another member asserted that the wish for legal uniformity is not a sufficient reason to harm the natural freedom the Jews enjoyed until then. But Joseph II thought otherwise and rejected all the suggestions offered by the State Council. His efforts to formulate a unified law system, and probably the Galician rejection of his own offer, were expressed in his insistence to use the law for non-Catholic Christians mentioned above as a model for the Jewish case. He repeated the argument that no exception should be made for Jews and instructed the compilation committee to draw up the draft for the formal application of the marriage law for Jews. It was turned into law on May 1786. Mendelssohn died 4 months earlier and did not live to witness it. To conclude, Mendelssohn's vision of the enlightened state did not fully correspond to the absolutist enlightened model of the Habsburg monarchy. But Mendelssohn was not a naive individual. It is hard to believe that he expected his vision of the ideal state to materialize during his lifetime. Had it not been for the use of the legal concept of the prerogative of the dominant religion, as a reason for discrimination, I think that he would have kept his initial enthusiasm for Joseph II, at least as a transitional figure. It is a Kirchenmacht, the power of the state as a privileged participant in the state administration and the legal system, that provoked in him the image of the wolf system of union against which the sheep must form their own farm. Thank you.